Welcome to the Hot Law Podcast, where we discuss the hot topics in today's news from the legal perspective. This podcast is brought to you by the Beaulieu Law Firm, PC. This podcast is not legal advice and is strictly for educational and entertainment purposes. For legal advice, visit the contact page at www.beaulieuLawFirm.com.
And yes, welcome to the Hot Law Podcast. I am your host, Max Beaulieu of the Beaulieu Law Firm PC, where we serve your corporate, business, sports, and entertainment needs. Visit me at www.beaulieuLawFirm.com, BEAULIEU lawfirm.com. All right, welcome to the show, episode 4. We are going to be talking about immigration, a very, very hot topic. Today's February 6th, so we are hot on the heels of the State of the Union by our president, and we know it's a hot button for him. In this day and age, there's a lot of immigration news concerning our celebrities and our certain citizens of the United States. So I got a very, very, very special guest to talk about it. Today, I'll introduce you to her very soon, but we're going to be talking about the basic immigration as it relates to entertainment and sports, certain celebrity immigration stories, and how a certain celebrity helped shape President Obama's DACA program and the Trump doctrine on immigration and how it has affected my guest law firm and overall immigration law. And my guest is the immigration extraordinaire, a very good friend of mine, and her name is Elektra Yao of the Yao Law Group. Welcome to the show, Elektra.
Thank you so much for having me. Thank you for the kind words and the warm introduction.
Absolutely, absolutely. So tell everybody a little bit about your firm and what you do and a little bit about your practice.
Sure. So we are a corporate immigration law firm with a focus on creatives and artists. We help our clients secure green cards based on their extraordinary abilities in the arts and in sports, along with temporary work visas to be able to pursue their craft in the U.S. and become the best artists and creatives that they want to be. My path to becoming an immigration attorney is actually a pretty interesting path because I'm actually the daughter of immigrants.
As am I.
My dad is from a country called Côte d'Ivoire, and my mom is from Italy. So I kind of grew up with that immigrant mentality of always needing to work hard and do the best that you can.
Absolutely.
And then I pursued art when I was younger, and when I was also in college. I studied musical theater for 10 years and opera, and I wanted to be the next Liza Minnelli. And I pursued photography and filmmaking when I was in college, and I got my film screened in Texas and in New York. I thought I wanted to go to law school and become a producer, but I started studying civil law and international law, and I really realized that I wanted to work in an international sphere, which goes back to my multicultural and international roots. So I worked in Europe for a couple of years before moving back to the U.S., where I decided that immigration law was the area of law that I wanted to practice in because of its complexities and because of the daily impact it makes on not only the lives of U.S. citizens, but their friends and family members as well.
Oh, fantastic. That actually may have answered some of it, but maybe you could expound a little bit. What value do you see about immigration law, and what's your overall affection for it?
The value of immigration law is inclusiveness. This is something that has been present in the U.S. history for a very, very long time. We have one of the most fully developed and complex immigration laws and policies, and we have striven as a country and as individuals to be accepting of different people. I'm a result of two people who come from different backgrounds and languages, just as we live in New York City, where there's so many different types of languages and smells and scents and different types of people and backgrounds. So the value of immigration is inclusiveness, and that's why I decided to practice immigration law.
Oh, that's awesome. I love hearing that. And so, immigration law is very vast.
Yes.
There's many different types, a bunch of type of visas. You got the visitor's visa, student visas. I think the most common work visa is the H-1B visa.
That's correct.
And but we're going to be focusing on, as some of our clients are in sports and entertainment, we're going to be focusing on the O&P visas.
Yes.
Now, how did the O&P visa came to be? Now, before the Immigration Act of 1990, and I'm going to be speaking more so on the sports side of things because sports law is more my background. Athletes relied more so on the H type of non-immigrant category visas, and they were not exclusive to athletes and entertainers as the O's and P's are today. Now, back then, the first type was the H-1B visa. It required a showing that the athlete was distinguished in his merit and ability in the field in which the athlete sought to participate in the United States. And that field of work and the services performed actually required, such extraordinary ability, kind of the term that's very renowned in the O visa. And the second type of H visa was the H-2B type temporary visa, and it was granted to those non-immigrants who sought to come to the U.S. in order to perform temporary service of labor for which no people in the United States is capable of in performing. Now, that's very tough because, like, particularly for baseball, anybody could play baseball. So to really distinguish yourself out of a bunch of people who can't play, it can be very difficult. But the reason why the Congress sought congressional expansion for immigrants, for entertainers and athletes was that, with the H-1s, you get lumped up with other type of non-immigrants who wanted to come to the United States.
That's correct.
And I think, correct me if I'm wrong, maybe you could expound on it. Is there like I think it happened back then, but even still today, there is a cap as to how many immigrants can come under the H visa?
Yes, there is a cap. It's capped at 65,000, plus it's a lottery-based system. Okay. So you only have a 33% chance of being selected. After you're selected, that's when you have to prove the merits of your case. That's still true today, but as you pointed out, athletes and entertainers and scientists and business entrepreneurs are no longer seeking the H visa to come and pursue their endeavor here in the U.S. The most appropriate visa, as you pointed out, is either the O or the P. There are other visa categories as well, but the O and the P are the most appropriate.
So that's interesting. So in your experience, like, what kind of non-immigrant workers would use the H-1B as opposed to the O and P?
Today?
Today.
So today, mostly people who use or who seek out the H-1B visa are people who work in the tech industry, people who work in Silicon Valley, or people who have very highly specialized skills or specialized knowledge in an area in computer science.
Oh, very, very cool. Okay, that explains it. All right. So today, now in 1990, the Immigration Act was introduced, but I think it was implemented in 1992. And it provided athletes and entertainers a more effective way entering to the United States to compete. The Immigration Act of 1990 created two categories, the O and the P. Could you tell the audience exactly what the O and P visas are?
So the O visa is reserved for individuals of extraordinary ability. It's one of the few visas that has a very, very high legal standard because essentially we need to prove that the athlete or the entertainer or the artist has reached the top 2 or 3% of his or her field and has sustained a high level of distinction. That basically means that we need to prove that the person is the top of the top. And sometimes you have people who are extremely qualified for the O visa who just cannot make that high legal threshold. U.S. Immigration officers are increasingly scrutinizing petitions nowadays, and they are applying the law very, very inaccurately and very, very severely, often resulting in those who are qualified not securing the visa.
Oh, that's understandable.
Unfortunately. The P visa is reserved for entertainers, for groups that will be touring, and for athletes. It has a smaller validity period compared to the O1, but the process of proving the distinction of the beneficiary is very similar to the O visa. The major difference between the P and the O is the validity period, which is why entertainers, athletes, and artists try to seek out the O visa because it gives the beneficiary a longer period of stay in the U.S.
Okay. Very good. Very good. Now, in my experience when I was, I used to be part of a, I don't know if you're familiar with CrossFit, where it's more of a functional fitness. A lot of people throwing weights, some gymnastic movements. Generally, it's a co-ed sport, but there was a new league. It was called Grid. Now, you couldn't use CrossFit. It was a trademark, so they had to, though it was the same kind of exercise movements, they couldn't use the term as it was belonged to another entity. So they named their sport Grid, in which they actually performed on a grid in which the mat looked like the grid, and it was about as big as a basketball court,
Yes.
94 feet long, 50 feet wide, with a couple of boxes, with a couple of grids, and where you had to race from the start to the finish line. And some of the rules, if the team would cross first, they would get 2 points. The team crossed second, they get a point. If you fail to cross within a certain amount of time, you get 0 points. Now the thing is with the P1 is general. In my experience, we used the P1 for athletes who were wanted to come to the United States, but they were well renowned and had achieved a substantial amount of merit in the sport they play. But the rule for the P1 was that you would have to have those merits achieved in a league that already existed in another country. Like, for example, Dirk Nowitzki, famous basketball player, he could have used the O or P, but if he wanted to use the P visa to come into the United States and play the NBA, he would have to showcase how much of a talented basketball player he is, and he's able to do so by showing the kind of MVPs he's won and awards he's won in, say, the league called FIBA, the Federal International Basketball Association. So he's able to do so. Now, my problem with my client at the time was the sport itself was the first of its kind in the United States. And we wanted to bring some international athletes to come in who participate in CrossFit, but we were a little bit different. So because we were the first of our kind, there was no way that we could use the P visa to demonstrate the accolades because there was no other international grid leagues at the time. So, I had to, I spoke to one of the lead attorneys of the league, and they said we should use P1. I said, well, I think we should use O visa. At least we could demonstrate the extraordinary ability of being an elite athlete. We could show they have a good gymnastic records, and sometimes, and you have your experience when you're applying for these visas, I think there's a recommendation letter, stating why this athlete needs to be here.
Definitely.
And why they have a special ability other than anybody else. And what I explained was that we need such great international talent to draw in an audience. And then with a new audience that likes the sport, it builds up a new business. So we could hire local people to manage the teams, run the concession stands, and build new other businesses surrounding the sport. So when we went through the O1 route, it was better. And we got it expedited. We had 2 weeks to bring them in, and they were able to come and perform at Madison Square Garden. So that's my little experience between the O1 and P visa.
Yeah, and I think that was a very positive strategic move on your part, because not only were you able to highlight the uniqueness of this new league and how forward-thinking it was and what a pioneer it was in the field, you were also able to highlight the extraordinary achievement of your client or the athlete and why he or she would positively impact this new league that you were creating.
Absolutely, absolutely. Now, would you have any stories about any O1 cases that you've had that may have been difficult, or any interesting tidbits in handling O visas?
Sure. So it's interesting that you mentioned the letters of recommendation, which in the O1 world are known as testimonial letters from experts in the field.
There you go.
I've written expert letters on behalf of some very, very famous people in the fashion industry, in the music industry, and so not so famous people. And one trend that I'm seeing with USCIS is that they are starting to reject these expert letters, stating that these letters written by experts are not sufficient to demonstrate that the beneficiary, that the client, has reached a high level of success in his or her field. And if you think about it in the real world, it sounds preposterous, because if Bill Gates were to write a letter of recommendation on behalf of one of his employees, that letter in itself is recognition that that person has done a good job, because no way would Bill Gates write a positive letter on behalf of somebody who hasn't accomplished something positively for his company. So the fact that they're rejecting these letters, which are very difficult to write because you really need to understand the profile of the beneficiary. You really need to understand the impact that the beneficiary has made in his or her industry and the future impact that he will make or she will make in the U.S. and the company that will be hiring him or her. So it's very disappointing that these letters are being rejected, because they are prime evidence, it's prime documentary support to prove that the beneficiary is a leader in his or her field.
Oh, very good. Very good. Very good. So let's talk about certain celebrities that have very interesting immigration stories, immigration stories. We'll work a little backwards, we'll work from the past, and then we talk certain things about
Sure.
some recent stories. Now, I'm a big comic book fan, and I love Superman.
My name is Elektra.
Oh, that's right. That's right. That's awesome. You ever watch Daredevil on Netflix?
I don't know anything about comic books.
Okay. You got a superstar name, but the person who made Superman, right, is an immigrant from Toronto, Canada. And his name is Joe Shuster, and he's an immigrant that contributed greatly to our comic book story. Superman's the first superhero.
Mm-hmm.
So this is another story of how immigrants can enrich. As a Canadian, enriching such great American culture.
Definitely. And I tell this to my staff, and I tell this to anybody that I meet. Our firm is directly impacting the cultural and artistic landscape here in the U.S. I represent Broadway performers. I represent top PR executives that are working with top brands in fashion. I represent fashion designers, jewelry designers who've exhibited in top museums and in top exhibitions and galleries here in the U.S. These immigrants, these foreign nationals are changing the way we are understanding and the way we are perceiving art. Mm-hmm. Art has always been inclusive, just like immigration has always been inclusive of different viewpoints and styles and ideas. And when you have foreign nationals come and bring their ideas and bring their history and bring their language and bring their story, they're directly changing what American art is considered today.
Absolutely. It's many years ago, it was to my shock. Now, I knew that basketball was invented in Massachusetts, but it was invented by a Canadian. And it started off with what was the story? I believe there was, it was winter time, and he was a gym teacher that needed to have the students exercise, so they got a couple of volleyballs and peach baskets, and they would just run around and throw the ball in the peach basket. Now, eventually, they cut the hole out, so it was easier to get the ball out of the basket, and the sport was born. Now, it's a billion-dollar industry in terms of the NBA, and it has effective lives, and it's such a part of our American canvas, and fabric rather, and some may say it has overtaken football and baseball as the best sport, as the most popular sport in the country.
Or the world.
Or the world, really. I think maybe right behind soccer.
Right.
Yeah.
Because basketball is played internationally in Europe, whereas I don't think football is played in Europe. You have, what's that other sport? That other sport that's similar to football.
Rugby.
Rugby. You
right.
have rugby, but rugby is not American football, whereas you have American basketball being played in Europe by actual American basketball players.
So I played a little rugby in law school. Very manly sport. Yeah.
How was that experience?
I was in law school, and a friend of mine was like, "Come on, man, just join in." And when you're in law school, you want to get the stress out, so
right.
you're just like, But I got popped really bad one time, and I was, I'm just gonna play it safe.
Well, thank God, because you're an excellent lawyer. So
thank you. So another special immigrant is Lupita Nyong'o. I always mess up her last name, but you remember her from 12 Years a Slave and Black Panther. Her story was, she was born in Mexico, and she moved to Kenya with her family, and when she was very young. Her early life was a difficult one with political unrest and general danger in the region, and it forced her family to leave the United States before her 20th birthday. But when she came into America, she graduated from Yale with a master's degree, and she went on to win an Academy Award, and
right.
and now she's an icon.
Well, she is actually a true example of a global citizen, because I represent many Mexican nationals, and when she actually won the Academy Award for Best Actress or Best Supporting Actress, all of Mexico was repping her because they had finally felt like they were represented in the arts. And for maybe somebody in America, that sounds counterintuitive, because she was only born there. She was raised in Kenya, but she is fully embraced by the Mexican community.
That's very interesting.
Yeah, which I think is wonderful.
It is wonderful.
It's truly representative of somebody who is a true forward thinker and leader in the global sphere.
I like the term global citizen, right? That's what she
Right.
really is. Okay, I think that's fantastic. All right, so I know you had a story about Amy Winehouse. She had a very interesting immigration story.
Yeah, Amy Winehouse is probably the most famous celebrity who's been denied a visa to perform here in the U.S., which everybody, I'm sure, comes as a shock to everybody because she has directly influenced pop music and R&B music and is considered to be probably one of the most influential and important singers of our time. But she was actually denied a visa because she was deemed a threat to the U.S. because of her unfortunate drug and alcohol abuse. So unfortunately, because her visa was denied, she couldn't perform at the Grammys.
So they would consider that a threat to the U.S. because she had personal substance issues?
Well, when you have to apply at the consulate, which is governed by the Department of State, you need to disclose any arrests that have occurred and why you've been arrested. Usually when you go in for the consular appointment, for the consular interview, the immigration officer or the consular officer will ask you different questions about your arrest and why you were arrested, because the consular interview is really the opportunity for the Department of State to weed out who has good or proper moral character and who is deemed fit enough to come into the U.S. She did not pass her interview because she had to disclose her drug arrests or her drug convictions, was subsequently denied and could not perform at the Grammys.
Oh, interesting.
Much to the disappointment of everybody in the entertainment world.
Well, I'm sure. God rest her soul. With a superstar, that's a little disappointing that she couldn't perform for her fans. And now let's talk about recent news. Shame on me. I kept in preparing for the show. I kept hearing about it, but I didn't dive into it like you did. But 21 Savage has an interesting story, I did not know he was a Brit.
It came as a shock to everybody. You're not the only one.
But tell us a little bit about it and as to the what happened.
So because it's a relatively new story, there are lots of different facts. But what I've gathered is he has represented himself to the entertainment world as somebody being from Atlanta, as a rapper or hip-hop artist being from Atlanta, which is very convenient for him because a lot of prominent rappers, such as Migos, for example, are from Atlanta. So right now it's kind of like a hot hub for people who want to emerge in the music world.
For sure.
So he represented himself as somebody who was from Atlanta, and he was recently stopped, and now he's in a detention center because a police officer ran a background check and realized that he was an overstay. Basically, an overstay is when somebody comes into the U.S. with an ESTA or a B1 or B2 visa, which is a tourist visa, and they overstay that visa. Typically, these visas last for 6 months. You can extend them for another 6 months. He overstayed. Once you overstay, that is technically a deportable offense, and he's been here ever since.
How long has been his overstay?
He arrived here in 2005 when he was quite young.
Yes.
So he's 26 now. So that would be maybe when he was 12, 13.
Oh, wow.
Which is probably why he doesn't have a strong British accent, if he still has one at all.
Now, this is really, correct me if I'm wrong. Like, is it that the longer you're in overstay, do they apply that same number of years of where you're not allowed to apply to come back to the U.S.?
Definitely. So the longer you overstay, so in his case, he's overstayed. We're into that 13 years. He would be subject to the permanent ban, which means that if he goes back or if he's repatriated to his home country, to the UK, he will be subject to a permanent ban.
Oh.
The only way to overcome that ban is if he has a qualifying relative, so either a U.S. citizen spouse who waivers for him, who petitions for him. He gets an I-130 approved, proving that he has a U.S. citizen spouse. And then a waiver is basically a pardon to the government, saying, yes, we acknowledge that he has overstayed his visa. However, I, as a qualifying relative, the U.S. citizen, will suffer extreme hardship if he were to go back to his home country.
So because I don't think he's married now, but if he quickly got married to a U.S. citizen, would that save him, or people would kind of would though the powers that be see that as trying to circumvent the law?
No, if he is in a relationship and decides to take it to the next level, then he can do that. But there are processing times involved. So in order to seek relief based on him having a qualifying relative, he will need to file an I-130 application. That petition is taking about 12 to 13 months to be approved. Once that is approved, then he can seek relief from the immigration judge.
All right. Interesting. Well, 21, good luck to you. Hopefully things work out. And not sure if you're going to hear this, but hey, good luck, buddy.
You can always call our law firm.
Absolutely.
Yao Law Group.
So let's move on. We're going to be speaking a little bit more on the public policy side of things,
Sure.
and but it will be celebrity related, and we're going to be talking about how a celebrity became an inspiration for a significant immigration policy, which is DACA, the Deferred Action for Children Arrivals. Could you tell us a little bit about what DACA is?
Sure. DACA is a policy that was put into place by our former President Obama to protect children who have arrived either with inspection, so meaning with a passport and that passport was inspected, or without a passport due to no fault of their own. Very often, immigrants seek a better life here in the U.S., and they will take their young children with them. Their young children do not have a choice in whether or not they want to come to the U.S. They don't have a choice in whether or not they overstay or not. And this policy really is to protect them for the mistakes that haven't been made by them. These are mistakes or these are actions that occurred by their parents. So to preserve their authorized stay here in the U.S., President Obama and his administration implemented the DACA program.
Oh, absolutely. And now these particular individuals, they're known as dreamers.
Yes.
I think because there was a DREAM Act in order to provide them with a path of citizenship, but I believe it has not been enacted by Congress.
That's correct.
Okay, and so. Pardon me, I'm coughing. Fighting off this cold. It was very cold in New York over the past 2 weeks, and everybody caught the sickness.
I think being cold is an understatement. It is freezing here in New York. Yeah. Not as bad as Chicago, but it is pretty cold here.
It is an affront. But back to the policy. The policy was announced by President Barack Obama on June 5th, 2012, and what it does is it provides temporary relief for those dreamers to not be deported automatically in a harsh manner. But now here's the thing: President Obama is a strict constitutionalist. So he fought this, not fought this. He was hesitant to do something like this. What do you call it? This is executive order because he didn't want to circumvent congressional power, but he felt like this was he saw wrong. And he felt like he needed to do something to save these kids because, for all intents and purposes, these kids are generally citizens. They pay taxes. They work here. This is the only country they know. And this is kind of quite a shock to me in my research, a lot of them serve in the military.
Right. So one of the requirements to be a recipient of DACA is that you must be enrolled in university, so either an associate's program or a bachelor's degree program or a master's program, or you must be working full-time. So these are people who are very, very integrated in the fabric here of the U.S. and who are very active members of community and of the U.S. society. What's really interesting, I find, about DACA, it's like you said, President Obama is a strict constitutionalist. But when you look at the number of potential DACA recipients, then you start to really look at the true application of the law, because not protecting these people or not giving them a period of authorized stay could potentially impact the U.S. in a negative way. These people, for all intents and purposes, just as you said, are American, just like you and I. They speak English properly, they go to school or they work, and they've only known the U.S. to be their home. So it would be incredibly unfair to punish them for something that they did not commit. Again, these are children who were brought into the U.S. at a very young age, so they did not have the intent to make that decision to either enter the U.S. or overstay.
Absolutely, absolutely. Now, President Obama, being a lawyer, so he did not create the DACA program out of thin air. So he, as a good lawyer, you try to find precedent for any action you try to implement. And it was a celebrity that helped him with the DACA program, and his name was John Legend.
Yes, John Lennon.
John Lennon, not John Legend. No, not ordinary people, guys. John Lennon, a former Beatle. So now, how did that came to be? Now, former Beatle, Brit, John Lennon, a Brit. He was in the United States, in New York, and he overstayed his visitor's visa. And because of his conviction with marijuana, it was difficult for his attorney, Leon Wilds, to get Mr. Lennon an extended stay. But Lennon had a great desire to stay here. So Wilds felt that he had to get creative. Now, he heard rumors about certain guys who had critical criminal backgrounds and bad immigration histories, and he sees that they're still around. And he believes that these guys benefited from what is now known as prosecutorial discretion.
Right.
The problem at the time was that Wilds, the attorney, Leon Wilds, did not have any proof that this kind of program existed. So what he decided to do was to file the Freedom of Information Act. And once he did that, I think a few months later, boxes of paper showed up at his office. And digging through that information, he found valuable information that confirmed his suspicion about about prosecutorial discretion, and it led to the U.S. immigration officials to kind of publicize the secret policy. And what the files showed was that for decades, the government had shielded some immigrants living in the United States illegally and shield those illegal immigrants from deportations because of their sympathetic cases. The Obama administration used that kind of policy and reasoning to push forward the DACA, and now it doesn't grant them a path to citizenship,
No.
but it gives them some relief. Now, the quote here from President Obama, he says, eligible individuals who do not present a risk to national security or public safety will be able to request temporary relief from deportation proceedings and apply for work authorization.
Correct. So DACA is a period of authorized stay. What the attorney did for John Lennon was figure out a strategy, figure out a way to demonstrate to USCIS that John Lennon was not a priority for deportation. It's the same kind of thing with 21 Savage, if you think about it. He had just been arrested for some petty marijuana crime. This is very different than being arrested for murder or any sort of felony or aggravated felony. But because of his high-profile nature, USCIS seemed to want to make an example out of him, the same with 21 Savage. It is very, very difficult for USCIS or ICE to go after European overstays. It almost never happens, although being an overstay is a deportable offense. So because it was such a negligible offense, and USCIS consular immigration officers have the discretion at that time, they had the discretion to not put him high on the priority list. It's the same thing with DACA. What Obama did, or President Obama did, was memorialize that discretion.
Okay, yeah, absolutely right. I totally agree. Now, as we stated before, the path to citizenship for Dreamers will require congressional approval.
That's true.
But for today's administration, there seems to be a wall, so to speak, that would prevent that from happening, which leads us to the Trump doctrine on immigration. Now, pardon me. Now, Trump's signature issues during the campaign was about illegal immigration and to some extent legal immigration.
Right.
During his campaign, he will often label illegal immigrants as criminals, even though the statistics bear out that native citizens have committed crimes at a higher rate. Trump has also sought out to severely reduce legal migration to the United States. Now, some of the critiques and policy that Trump proposed or tried to enact is one of which is the birthright citizenship, in which he talked about and attempted to roll back the citizenship of students, of those who were born here from undocumented immigrants.
Right.
He-
And sorry to interrupt you, but that is kind of a doctrine that is applied in most of Western Europe. There's the doctrine between jus solis and jus sanguinis. So jus sanguinis is based on citizenship, based on your bloodline, right? And jus solis is citizenship based on you being born on that territory. So let's take me, for example. I do not have American blood because my father is from Côte d'Ivoire and my mother is from Italy. However, I was born on U.S. territory, and that makes me a U.S. citizen. That is based on the jus solis doctrine. By eliminating that doctrine, Trump will make it so, or President Trump and his administration will make it so only those people who are born from U.S. citizen parents will be able to get U.S. citizenship. And if you think about it, this is not something that an illuminated country does. This is something that if you look at the current immigration status in Europe right now is countries like in like Hungary, for example, like Poland, like Italy. These are countries that are restricting the number of people who can become citizens in their countries specifically because they do not have Italian blood or Polish blood or Hungarian blood. And this is not something that an illuminated country does. Countries like France, for example, countries like the UK, they recognize both jus solis and jus sanguinis, something that the U.S. currently does right now. So in the U.S. right now, if you're born on the territory, you are American. If you're born from U.S. parents in India, you are American.
Oh, okay.
It's the doctrine of jus solis and jus sanguinis.
Oh, thank you for that. Wow. I was going to ask you, like, if you had U.S. parents but you weren't born here, you would still be considered U.S. citizen.
That's correct.
Okay. All right. But if your parents are not from here, then you're not considered a U.S. citizen if you're born here. Well, now, but under his rule.
If he were to make those changes, then yes. And if you think about it, that would alienate all the different blended and international, globally minded families that we have here in the U.S. And it's not only New York City. For example, Texas has the largest Nigerian population in all of the U.S. San Francisco has a very large population of those of Chinese descent. You cannot penalize somebody for their cultural heritage, and that's what he's trying to do. And it's an abomination for America and what America represents. America has always been or has striven to be a country of inclusiveness, and penalizing and punishing people just because their parents have a different culture or national origin is anti-American.
Absolutely. So that's birthright citizenship. He also talked about and enacted and pushing. I'm not sure you can explain the status of it, but the Muslim travel ban. Now, I'm not sure did the Supreme Court allow it now.
Upheld it, yes.
Upheld it. Now, where is it now? How is it being implemented? Like, what's going? Do you have an idea what's going on with the Muslim travel ban?
Well, it's been upheld by the Supreme Court, so it's being enforced. So certain there are 7 countries that were on the list, and those nationals of those countries, for example, if they had been approved for an immigrant visa before the ban. So before Trump enacted this ban, they would be able to apply for a waiver and still come to the U.S. If, for example, any sort of immigration movement has been made for a case for them, they would not be able to come to the U.S. So that ban is still in place.
Okay, absolutely. All right, and then he's speaking about phasing out DACA. And now this has been widely criticized by business leaders because they say it would be unfair and, as you stated, a tremendous harm to the economy. And he also talked about the cancellation of temporary protective status.
TPS, yes.
And zero tolerance policy and family separation on the Mexican border. Now, what's been happening now is big law firms have stepped up and sued the administration for a lot of these, what they deem unfair and cruel and unconstitutional policies and practices. And it's
also the Attorney General of New York sued the Trump administration for what happened with DACA initially in his early administration.
Yeah, absolutely. So there's a lot going on. A lot of busy lawyers out there. Law firms like Paul Weiss have stepped up. I think Covington as well. So it's there's a lot of people who believe in immigration and what this country was founded on was founded by immigrants and what the country as it is today and it's what makes this country great, and people are really volunteering their time as well to really protect these people.
And I think law firms or big law firms are standing up to this sort of overarching evil immigration spirit, because if we look at the facts of these individual DACA recipients, you have to either be working or be in school to be a DACA recipient. So these are individuals that are actively contributing to the intellect of the U.S. and to the economy of the U.S. They're not doing anything wrong. It's like as if the administration wants to take a carpet from under these young people and leave them out on the streets when they're not doing anything wrong. Like I said, these are young people who did not come to the U.S. because they chose to. They were brought here as young babies or as young children without that preconceived intent to want to overstay. They are in school, they are in working, they are active members of their communities. There's no reason to want to rescind that other than for political gain.
Right. I agree with you. I agree. Now, what we're going to be talking about, and particularly with you, I just read an article and been doing my research on WBUR.org. I believe it's a radio station, but they have they do articles there as well. And the article is, "What's it like to be an immigration lawyer in the Trump era?" Now, a few excerpts here I'll read real quickly. Now, there was a lawyer who stated that, a lawyer's comfort in the courtroom or even in consultation comes from knowing what to expect, including potential surprises. But with the Trump administration throwing, as she's called, ninja stars in all directions, lawyers are left guessing what innovative grounds for denials or deportation the government will come up with. And she has an example of dealing with the immigration client, and I quote, "Take, for example, the fluctuating advice I gave to a client whose mother was scheduled to travel here from a banned country only a few days after Trump issued his order. After we had no choice but to accept that Air France stopped her from boarding her flight, then when a federal judge enjoined the ban for an emergency 1-week period, I advised that she could travel legally after all. The catch was she needed to travel on another airline, the only airline following the judge's order, because apparently other airlines were not following the judge's order and stick with Trump's.
They were afraid of sanctions.
Yeah, okay, absolutely. And shortly after she purchased her new ticket, another federal judge denied the motion to extend the injunction period past its 1-week Sunday deadline. Now, and that was very scary for the attorney. Now the attorney said that the client was able to squeak through and travel to her last point destination, but. Right. I just want to get your point of view as an immigration attorney in the Trump era. Have you experienced similar circumstances where your advice had to fluctuate?
Definitely, there have been a lot of changes, especially on changes that haven't occurred in 30 years. I'm thinking of a green card client, and we had applied for his green card. We got his green card approved, and the Trump administration just issued a policy memo about instituting interviews for employment-based green cards. This is something that has never happened in the last 30 years. This is something that's relatively new. So imagine the chaos that ensued for immigration attorneys in terms of preparing the client on questions that we didn't even know what would be asked. Or, for example, the immigration officers who weren't adequately prepared to interview the client. I mean, what were they going to do? Were they going to ask the client, so why are you extraordinary at what you do? Why are you great at what you do? I mean, those were some of the questions that were asked by immigration officers, but they weren't the right questions to be asked in terms of adjudicating a green card. For example, one of the most probably important changes for my practice has been a policy memo that was issued towards F1, so students, and M1, vocational students. So now, for example, I haven't seen it implemented in my practice, but there is this risk if a student applies for a visa and that visa is denied during the student's grace period, that person could potentially be issued a notice to appear in front of an immigration judge. And that basically means that client is in immigration proceedings. That is something that's very, very serious, just because an application for a work visa was denied. So the way we have tried to overcome this huge burden of constant new information coming in daily is to remain updated with our clients and to maintain a strong flow of communication with them. We periodically send them memos that we write so that we can explain the new changes of the law and how it affects them. As far as the new denials that are coming through, I was recently contacted. I represent a modeling agency here in the U.S., and a client of theirs was denied. Another attorney had worked on their case, and this is somebody that is a very famous model. This is somebody that if you see her for these major brands, you would if you see this person, you would recognize this person and the brands that this person represents. And I read the denial notice, and the denial stated that there was no proof that this person would be working here in the U.S. Well, that's nonsensical, because if you're applying for a work visa, it's because you have proof that you will be working here in the U.S.
Absolutely.
So there's a lot of I'm seeing in terms of the cases that we're working on, immigration officers who are just not actively reading the cases and reading the documentary support that was submitted with the case. So oftentimes you have to re-argue and relitigate the case twice, which causes a delay for clients and a delay in the case.
Oh, such a mess, all this backlog that's created.
Absolutely.
All right, so that kind of leads to our next point. Now, in preparing for this podcast, Elektra and I spoke about this last week, going over the rundown I presented to her. And, one reason I was excited about this episode is because some of this extra stuff that we're talking about here. And so far, so good. It's a good episode. Now, we talked about the immigration process in terms of the immigration officers and how they're handling their job. Now, in my research, in terms of reviewing these immigrant applications for these visas and whatnot, under the Obama era and before, they were encouraged to get to a yes, to apply, to review the application, see what they have, but try to get to a yes. Whereas under the Trump administration, there's a little bit more scrutiny. And you expressed a little bit of frustration of how they're handling it in terms of immigration officers versus immigration attorneys. So,
right.
Explain your opinion.
I don't want to make it about President Obama and President Trump.
Oh, no, no.
The legal standard for adjudicating petitions is preponderance of the evidence, which is basically 51%. So it is a low standard in terms of the lens that you have to look through when you're looking through these petitions. There was also a policy memo that was written prior to the Obama administration that stated that if a client was currently in a certain non-immigrant status, so let's take an O visa, if a client was in an O visa status, the extension should be deferred to the approval because the original case was approved. That policy memo was rescinded by this new administration, which means that extension cases, so people who have been working professionally here in the U.S. for 3 years, need to be adjudicated or need to be relitigated as if they were fresh cases, meaning that everything that was on the record previously is no longer being taken into consideration. This is something that is very, very frustrating and very, very difficult in practice, because it's difficult to explain to a client, well, this is a change that was made, and unfortunately we need a more evidence to prove that not only what you did in the past, but what you are currently doing now. But there were laws in place before the Obama administration to protect these petitions. So the overarching spirit in the prior administration was your right to get to a yes. Very soon after Trump came into office, I was at an AILA meeting, and AILA is the American Immigration Lawyers Association here in the U.S., and one of the representatives had spoken to the USCIS liaison, and that person had declared that he or she was happy that now he or she was doing his or her job properly in terms of denying cases. So that's probably the most problematic thing that we have right now, is this overarching spirit of wanting to deny cases, even though the law states that you must adjudicate the petition with the preponderance of the evidence standard, which is 51%.
Absolutely.
So more likely yes than no.
Okay. Well, there you go. All right. And now, two quick closing points. Now, hot on the heels of the State of the Union, which should have happened, I believe, 10 days ago, but it didn't happen because there was a shutdown, and the whole back and forth between
President
Pelosi.
Trump is a PR master.
Absolutely. And so now, and because there was a shutdown over the wall, and now, what do you think about now? There's threat of a looming shutdown, possibly on the 15th or afterwards, regarding this immigration policy and the wall. What's your thoughts on that?
On the wall?
On the wall and the shutdown and everything that's been going on.
My thoughts are extreme disappointment in this administration and the lack of regard for the American people and our families and our friends. This chaos, this disorganization is just a rouse to make us not focus on what's important, which is inclusionary policies and policies that reflect American values, not only here on our American territory, but also internationally. America is the leader of one of the leading countries of the world. We are a country that other countries look to as an example, and this is something that is quite embarrassing for immigration professionals and for politicians, frankly. This issue of the wall is not something that is rooted in law. It is something that is rooted in the game of politics, which is unfortunate because there's always somebody that loses in the game of politics, and the people who will lose in this game are people who are innocent, and that's not American. We do not punish innocent people. We do not punish people who are trying to improve themselves. We do not punish people who want to better themselves. We encourage people to pursue the American dream. That's why that idiom, American dream, exists. There's no Italian dream or French dream. It is the American dream. And building that wall is just a rouse to get us to not focus on what's the most important thing, which is cooperating as a government, cooperating as professionals to make sure that this country continues to propel itself to be the leader of the world.
Absolutely, well spoken. And you may have just alluded to this, but one final question or statement, and I'd like to get your explanation now. Now again, President Trump. And a lot of people have believed this to be so, but he's been more on it and has a megaphone about it, saying that our immigration laws and policy are broken, and they're severely flawed, and it's a complete mess. And you and I just spoke about that last week, and I would love to rehear it, at least for the audience. You could tell them, like, is our immigration laws and policy a mess? Is it broken? Is it in a sad state, as he explains it?
So I'd like to preface what I'm going to say by stating that and confirming that immigration law and policy is quite complex. The number one reason for its complexity is that we have multiple sources of law. Our law comes from policy memoranda that's issued by USCIS. Our law comes from executive orders that are drafted and signed by the executive, by the president. Our law comes from the federal regulations. Our law comes from the Foreign Affairs Manual, which is a manual that's applied by the Department of State, which are the consulates abroad. Our laws are judge-made law, so immigration courts, BIA appeals. We have many, many different sources of law to help us reason through this very complex area of federal law. With that being said, I do not think that it is a broken system. I think it is actually a quite sophisticated system that lends itself to uniting families, that lends itself to letting entrepreneurs pursue their business ideals here in the U.S., and that lends itself to people seeking permanency here in the U.S. based on their extraordinary ability in the arts. Just like, for example, President Trump's wife, Melania Trump.
Absolutely.
She is a recipient of the EB-1A, which is a very, very high legal standard to obtain. It's colloquially known as the Einstein green card, meaning that only people who are the best, the top, the superstars of their field can secure this green card. So while it is quite complex, it provides for different ways of, as I said, uniting families, enabling entrepreneurs and business owners to obtain their American dream, and pursuing the arts. This is something that is not quite as developed as Europe, for example. And I know this because I volunteered with refugees and with immigrants in Italy, where Italy, for example, has a very weak and young and immature immigration history and policy. And this is based on their lack of colonizing the African nations, very different from the Netherlands or France or the UK, where their immigration policies are much more rich because they have long-standing ties with countries that were located in Africa, which is why countries like the UK and France have the jus solis policy, where if you are of Nigerian parents, but you're born in the UK, you are a British citizen. If you are from Senegalese parents and you're born in France, you are French. So it is not broken, but there is definitely room for improvement to help navigate through these different layers and to make it easier for practitioners to secure an approval for their clients. Another thing that makes immigration law very difficult to practice is that the people, the immigration officers or the consular officers who are adjudicating these petitions are not attorneys.
Right.
These are, there's maybe 1% to 2% of immigration officers that are attorneys, but that is very, very low in the sphere of the immigration officers that are adjudicating the lives and the livelihoods of people who are filing for immigration and non-immigrant benefits. This is what makes the job very complex, because you have to be able to explain very complex areas of law to people who probably didn't go to college, to people who probably don't have the same legal training or legal experience that you have. And that is something that is very, very difficult to do. It's one thing to have a 30-minute or 1-hour consultation explaining the law. It's another thing to write a 50-page legal brief explaining why the person needs to stay in the U.S.
Oh, okay. Well put. Well, that was fascinating. Thank you for your point of view. And that pretty much wraps up our episode. DJ, kick up my outro. Well, thank you so much. Please check out the podcast on iTunes, Google Music, what is it? iHeartRadio.
Thank you for having me.
And on YouTube. And visit www.boyolawfirm.com for your sports entertainment needs. Visit the YaoLawGroup.com.
YaoLawGroup.com.
For your immigration needs. Thank you for listening. Have a good weekend, and I'll let you boys.
Thanks, everyone.